Justice Kavanaugh?
I just want to focus on the actual dispute as it exists now, today, between the government's view of EMTALA and Idaho law, because Idaho law has changed since the time of the district court's injunction, both with the Idaho Supreme Court and with a clarifying change by the Idaho legislature. You say in your reply brief, and so too the Moyle reply brief, says that for each of the conditions identified by the Solicitor General where, under their view of an EMTALA, an abortion must be available, you say in the reply brief that Idaho law, in fact, allows an abortion in each of those circumstances, and you go through them on pages 8 and 9 of the reply brief, each of the conditions. Is there any condition that you're aware of where the Solicitor General says EMTALA requires that an abortion be available in an emergency circumstance where Idaho law, as currently stated, does not?
So certainly the administration maintains that there is such conditions. The ones they identify in the affidavits.
What is your view? And
my view is that yes, and I'm going to reference footnote 5 from the gray brief, the mental health condition situation. The administration says that's not on the table. That's not a scenario where abortion is the only stabilizing care required. And I'm not sure where that construct of only stabilizing care comes from, because under their view, it's the doctor's determination that controls, not this imposed only requirement. But be that as it may, the American Psychiatric Association, and so I'm taking General Prelogger up on her offer in footnote 5 that there are no professional organizations that set abortion as a standard of care. The American Psychiatric Association, in a 2023 position paper, says that abortions are imperative for mental health conditions. That sounds like a necessity to me, and I don't know how, if a woman presents at 7 months pregnant in an Idaho emergency room and says, I'm experiencing severe depression from this pregnancy, I'm having suicidal ideation from carrying this pregnancy forth, that wouldn't, under the administration's reading, be the only stabilizing care.
So you think the Ninth Circuit panel, when it said every circumstance described by the administration's declarations involved life-threatening circumstances under which Idaho law would allow an abortion, that's what the Ninth Circuit panel said? We agree with that, because the conditions identified in the affidavits were all conditions that would fit under the life-saving exception. And that's telling, because these doctors, when put under oath in an affidavit, couldn't come up with any of these harrowing circumstances. They identified other ones. But I think what the government doesn't want to talk about, again, is the mental health exception here. That is, I just don't know how you can read their understanding. I'm just trying to figure out, is there other than the mental health, which we haven't had a lot of briefing about, is there any other condition identified by the Solicitor General where you think Idaho law would not allow a physician in his or her good faith judgment to perform an emergency abortion?
Not in their affidavits. They maintain, nonetheless, that when you compare the definition of what an emergency medical condition is, it is broader than the definition of the life-saving exception in Idaho law. And so they present—
Well, that's what they say, but then when we get down to the actual conditions that are listed, the examples, and Justice Sotomayor was going through some of those, you have said in your brief, at least, that each of the conditions identified by the government, actually Idaho law allows an emergency abortion.
And I agree, and I think the injunction here is
so
also—
what does that mean for what we're deciding here?
Well, what
if Idaho law allows an abortion in each of the emergency circumstances that is identified by the government as EMTALA mandating that it be allowed?
I'll say two things. I mean, the real practical first response is that Idaho's under an injunction that includes an incredibly broad requirement that preempts state law.
Right. I understand that, and that may mean that there shouldn't be an injunction. I take your point on that. What's your second?
My second point, Your Honor, is I don't know how this court can make the determination on whether there are any real-world conditions without first answering the statutory interpretation question of what EMTALA's stabilization requirement actually requires. That has to be addressed. It has to be addressed not only because that's—
Well, I was just picking up on your reply brief. You're the one who said it in your reply brief that there's actually no real daylight here in terms of the conditions. So I'm just picking up on what you all
Yeah,
said.
I understand, Your Honor.
Thank you.